the employee later. So in that case, there is any document phase. You all have not booked. So all these factors, what I'm saying now is we will be discussing it here. This is not changing. You all people fall under any university or it is an individual organization? Individual organization. Affiliates to a university. So you all might be having a blanket university document under which there are laws which will be applicable to your organization. Now, all of you all have any IP policy in place? I think DY Patil has one. You all have a policy. Any one of you all have an IP policy in place? Any idea what is an IP policy? Why it is required? So what we do here is, what is IP we have seen. It's an intellectual property. Now why any organization needs to have an IP policy? Okay. See, organization is a place which is giving you everything. Okay. It gives you research area, it gives you a facility, it helps to develop your idea. Okay. So when I am giving you a facility, I also expect something return from you people. Okay. It's not that I am doing philanthropy, I'm just giving it off because I have a lot of money, okay, or I just want to give it off. No. When I am giving you a facility, I want that by using that facility, you develop something. When you develop something, it becomes useful to the organization in terms of monetary benefits and in terms of also scaling up ethically, in terms of scaling up on a point where university is recognized or your organization is recognized for the knowledge that is coming out of your organization. Okay, so you all are affiliated to educational organizations. Okay, no one is from R&D here, right? All are from educational background. Okay, so it is the quality of the students in your case. What are the best teaching that you're giving to your students and how they come out. So that is what is one part which is expected out of you. But in spite of that, there is also intellectual property. Now she said she has developed a copyright, she has already filed for it, or she is going for a patent. When she files for a patent, she has filed it. Why? Because the organization has supported her, okay, to develop that idea. If individually she had to do it, could be she wouldn't have developed it that well. She has to put in a lot of her own money, she has to develop one place, she has to take those instruments, whatever might be that case. So the need of an IP policy is for the organization and also for you faculty members to get maximum benefit of whatever knowledge you all are developing at the organization. So it helps you people also to get certain benefits out of it, and it also helps the organization to develop on it. So that is why every organization needs to have an IP policy. This policy was for MIT, Massachusetts, which is the best known policy today. Every organization has developed their own. IITs, if you all just go on their website, all IITs have good IP policies. They can be calculated as benchmark policies on which you all need to develop depending upon how your organization is related. Okay. Now what is a policy document? Okay. All of you all have insurance policies. Okay. You all have your licenses. Everything is there. Every policy has certain headers under which a policy is defined. And this is a legal document, so it has to have certain definitions. It has to have certain sections. Okay? And whom this policy is meant for. Now when we say insurance policy, what we say that for the age of 60 you will be given so much amount. If you have a cataract operation, you are eligible to get so much amount. Okay? That is how a policy is defined. In a similar way, when we define an IP policy, there are certain responsibilities which the organization has, the certain responsibilities which you as an inventor, you as a faculty member have towards the organization. So it is a give and take where every organization has to have in place as a defined, it gives you a boundary on which people can work or the organization as a whole can work. Okay, so these are certain table of contents. These are normal ones, you can have better than this also, you can go in depth also, but I am just giving you a general overview of what can come under an IP policy. Now, every policy has to have a goal. So what can be a goal of an IP policy? Forget reading all this, but what randomly do you all think? Can an IP policy, what can be a goal of an IP policy? As I said, an insurance policy, you all know what is the goal of an insurance policy. So if you have any medical emergency, it will help you to get money out of it. So what, with simple explanation what I have given you all, what do you think can be a goal of an IP policy?
The intellectual property which an organization holds should remain within the organization.
Other than that, yes. That is one clause. Goal as
More innovations.
right, one of it, yes. So motivate you people to do more of research, to do more of IP, to help the organization to develop. Okay. So any IP policy comes with a goal, it comes with an objective. When I have a goal, I have an objective of how I can implement that goal. Okay. As she said, my goal is what? I want to motivate my faculty members to do more research. And how will I do this research? How will I motivate you to do research? What I do, I say I'll give you some incentives. Okay. I'll give you some share of it. Okay. Or I say, if you do so much sum of patents and if you commercialize it, there's a clause in that out of the 100% that the university gives, 40% will be given to the inventors. Okay. So this is how you design a policy which will benefit the organization as well as the inventors. Okay. So the goal and objective, it has to be very well defined when we draft an IP policy. Every organization needs to have an IP policy in place because, there might be leakage of certain IPs which go out of the organization which is unauthorized. Now we have seen, like I'm just giving you the exact structure of an IP policy, what all comes into it. When we start drafting an IP policy, you should understand the type of IP. So whatever we have just discussed before, all that is well defined in your IP policy. Why it needs to be defined is, it gives you the boundary of your IP. When I say patents, it will tell me under patents what all will be included by the organization. Okay, so it could include your formulas, it could include your products, it could include your processes. So you need to define each of this IP very specifically when you draft an IP policy. Now, whom is this policy applicable to? So, try to compare this with your insurance policies everywhere. Okay, in that also we define whom the policy is applicable. It is a floating one. It is applicable to my entire family, or it is only to my child, whatever it. Similarly, the policy is applicable to whom? The people who are working in your organization is one category. Students who come and go out, so it's applicable to them. Any visiting faculty members who come, so they might come say for a short duration of time, 6 months, 1 year. In that case also, they will have to sign this policy document. Why? Because in that duration of 6 months, whichever they are there, say at DY Patil, he visits as a visiting faculty here. He develops some product, he develops some process, but he has developed it in the premises of DY Patil within his tenure of DY Patil of 6 months. In that case also, this policy document will be applicable to him. Then the obligation of this policy, so whatever are the sections under which I have defined this policy, this will also survive the termination of the employment. So tomorrow she leaves the organization, she goes and joins another organization. In that case also, whatever IP you have developed at DY Patil will be residing with DY Patil. It doesn't go out with her. Okay? Whichever other organization you join, it will be differently for them. But whatever she has done on the tenure of this premises, it's applicable to her. It is enforceable, as I said, on all the people who are working here. So it is right from your professors, scientists, students, even the university staff, so he is the main inventor, I'm saying, and all 4 of you are helping out to develop that invention. In that case, all 4 of you all have the obligation of this policy that whatever has been invented in this premises belongs to the university. Okay, we'll see under what conditions he can take it on his own, but by larger rule, whatever is developed by the organization stays with the organization. It is not being passed on to the individual person.
In that case, if we are employees, but if you invent something other than our working hours.
Yes, yes, that is mentioned in the policy document. We'll see how to tackle that. But there you have to substantially prove that you have not used any resources of the organization. The idea, whatever, has no conflicting idea with what you're working here. So So now if you're working on a pharma formulation here, and at your home, if you're doing something totally different, it is fine. But if they are, conflicting ideas, what you're doing on your own and what you're doing here, in that case, you are not supposed to. So it doesn't fall under the ambit of this policy. So the policy has to be defined in such a way that such conflicts are avoided. Otherwise, every person, will come up with his own thing and go on. In the organization, if you think from the point of view of an organization, it doesn't benefit the organization at all. Because they have put in so much of resources in you. So somewhere, the organization should be helped out. This part I was saying. So upon commencing an employment, so when I asked you all, have you all signed anything, where they have mentioned something about the IP. In the appointment letters, usually big universities and big organizations do mention a clause related to IP. So anything, I would suggest that once you all go back, just as an exercise, scan what has been written in an employment letter. Okay, because I'm very sure most of us don't look into it. We just sign because we got a job, and that's a natural human tendency. But as a study or as an understanding, try to see what your organization has mentioned in terms of IP. And now most of even the upcoming universities or upcoming educational institutes do have this clause. Okay? So this is called as a background IP. So if she is working today in DY Party, as I said, she passes out and she goes and joins some other organization. Say she goes and joins Symbiosis. In that case, whatever IP she is carrying from here, or whatever IP she is developed there will be a clause whether how much she can carry from this organization to the other organization. Okay? So she has to declare, now she has a copyright, so she has to declare in the other university that I already own a copyright on so and so material. So this all comes in your employment clauses. Now his question on ownership of rights. There are two ownerships which are present. One is the university owns the IP which is created by the researchers. This is very obvious. So I am an employee of DY Patil. So whatever I have created here, by default the parent organization owns that right. Second is the third party ownership. Now where this comes into picture is when you are having R&D projects which are funded by different organizations. Okay. So as she said, they have an industry project. Okay. Industry is giving me the entire funds. In that case, who is the IP lying with? Such cases, the IP is governed by an agreement which forms between your organization and the industry. This is an exclusive agreement which will state that whatever is the IP which comes out of this research will decide who the IP ownership is. Now how this is decided? This is decided upon the percentage of research that you have done. He puts in, as a DY Patil employee, he says he puts in 50% of his work, energy or your idea. Industry who has sponsored, they give you only the space, they give you for all the material, they give you the money. But they are not contributing to you all in the IP or the intellectual point of view. In that case, he can claim for the IP ownership. But that should be mentioned very clearly in the policy. Okay, in the policy document. But in that case, if the industry is also adding 50% of their knowledge, he is adding 50% of the knowledge. In such a situation, the agreement will say there is 50-50 partnership of the IPO which is being coming out of this funded project. Okay. Government agencies, they work totally differently on IP ownership. So usually government funding agencies do not claim any IP on whatever they have given because these funds are distributed by the government for development itself. So, but it is depending upon which funding agency. If you have BIRAC, you have NBA, you have seed funding, it depends totally on which government agency is giving you funds. Yeah.
Say for example, I am doing some research, okay, and initially I didn't have in my back of the mind that I need to turn out into a but later on I found out that this particular research I can go for this startup. But I have done that particular work during my excluding my working hours or so, but in the premises.
Right.
So in that specific case, if I am going for the IP, the applicant of the inventor is going to the college because
if you have used space of the organization, okay, lab space, university comes into picture.
So in that
Substantial use of any lab space of the organization has a right on that.
So in that specific case, if I want to go for this startup company later on,
That we will see in the startup policy, how you come out of all this, or how this institute can support you in start if you go for a startup or a spin-off. So this is IP policy. Why this is a blanket policy that defines the boundaries of how your IP will be distributed. Okay. But when it comes to specific cases of entrepreneurship or your startups or your spin-outs, which you might come up with one of your students, in that case, what are the rules which are applicable? That means how it is done.
Also, ma'am, say for example, I am an employee of this particular organization. It's fine that I am using the resources provided by the institution and I am working in their lab, so it's very obvious that they will be the
Applicants, yes.
But the IP is of mine. I am putting my energy, I am putting my time.
Still, you are employed by the organization.
Right, but the inventor should be the college or
Inventor is the person who is worked on. But in that case, you have to establish that you are an inventor. So when we file a patent, there is a form which is called as inventorship. Okay, where we say that I am the first inventor and because of me this idea is developed. So you have to establish, or the organization has to establish that you are the true inventor. It is called as a true inventor of your of this idea of this technology. So it might always happen that you have the I just come back. You have the more idea. She has helped you to develop the idea. In that case, you are the first inventor. She becomes the second, and the organization remains as the applicant. So the patent rights go on the name of the organization. As an inventor, you can always sell it off or do anything, but the IP is owned by the organization. Always. Yes.
Ma'am, in case the organization, like I'm using organization's resources, so like the patent will go to the organization's name. But what if I am providing monetary value equivalent to the resources I used to the organization? Then can I get the patent on my name?
You cannot get the patent unless and until the management decides that I want to assign it on the inventor's name. So there is a committee usually. I tell you, it goes further down the line. We'll see how an IP policy in such cases. So waiver of rights is something that you're talking about. Okay. So this is the exact part that I will come to. Waiver of rights is what that you are an inventor, and say a company comes to you, say Pfizer comes to you, okay, and Pfizer says that no, only this inventor and his knowledge, only then we will go for licensing with you. In that case, if the Pfizer company says that your name?
Mohit.
Mohit. Pfizer says that only Mohit can, if the patent is assigned to Mohit, then and then only we will go for licensing and we will pay you the royalty. In that case, D.Y. Patil can take a call, the committee can take a call of assigning the patent to Mohit, and then Mohit can license it out to Pfizer.
Okay.
So that is on case-to-case basis. But as I said, this is a blanket policy. It is applicable that by default your organization is that.
Even if I pay the monetary value equivalent to
Yes.
the resource.
Because that monetary has come out. Why? Because they helped you to develop it. So that.
No, I'm asking about, like, for example, I'm using A, B, C as a resource. It is available in the college, so like I can use it quickly. Like the time consumption will be less. Instead of finding the resource, then purchasing it from there. So like I can provide the value equivalent in the market of A, B and C to the college, and instead of it is like something I'm purchasing instead of from the vendor, I'm purchasing it from the college. So in that case,
yeah, but still the college will not let off its rights. Why I tell you, because tomorrow if there's something really big comes out of your thing, college will lose out, the organization will lose out. So in the IP policy, usually if the case is very specific and the third party is asking only Mohit to be there, only in that cases they do. Else no organization will.
basically one content where you are doing in college premises. End of discussion. It would be
Any substantial use of this, even the table and chair you use, and you are into the policy.
it will be of the organization.
that is the
How else
content
will be the
label.
organization benefit, right? Why will they invest on it? So that specifically comes in this waiver of rights. So this part is very important. Why I tell you? As I said, it is established that ownership of the inventor would be essential. Okay? Sorry. Yeah.
Regarding ownership, if I am utilizing best of University of Delhi, but this project or site is funded by the third party, then who is the owner?
In that case, as I said, there is an agreement which happens. Okay, so you are getting say funds from an industry for developing this project. Okay, you are doing it at the university level. Fine. You are getting say some X amount, say 10 lakhs you are getting, and you say that they have given you a specific problem. You are finding a solution. In that case, there's an agreement which happens between your organization and the company who's giving you sponsorship. If you are the person who's putting in all the intellectual efforts for developing that formula, in that case, the ownership lies with you, and they are going giving you only the money to develop. But if that agreement says that in spite of you having putting in all your intellectual efforts into it, say 50% of it, still that agreement defines who the ownership will be. So usually they put it 50-50 because what happens is tomorrow down the line, when I'm scaling up that project and I have a problem, I have to come back to you, right? As a company, I cannot do that. I'm just giving you money, but you are the person who has developed it. So 50% ownership lies with you, 50% lies with that industry. Because further down the line, what happens, I tell you, when he goes for commercialization or getting that product into the market, if he doesn't have your rights, I don't have my own rights, I will not be able to sell the product. Okay, and then whatever amount I do, what I will say is, I sell 10 units, and depending on whatever I've sold, whatever royalty I'll give, I'll pay it to you. You're okay with it as far as you're getting your money out of it.
That's how it works. And suppose I have filed a patent and I'm working with one organization and half of the work is done in the first organization and in between if I have to leave that organization, then in that case
What happens, I tell you, you have to take a permission from your parent organization that I'm taking this IP to the other organization. So say from DY Patil you are going to Symbiosis. Symbiosis you have to declare that you are doing something IP here. If DY Patil doesn't give you a permission to work on the same, you cannot take it out of your organization. That you have to stop it. So these all terms come in your policy. But how it happens is if you can convince the management that this is how I'm going to develop it, or down the line if even any IP comes, I will assign it back to you. I will not assign it to Symbiosis. In that case, could be you all can convince and take that IP right now.
but where to carry out that leftover work?
Usually, how it happens is in your organization, if you all have processes in place, it goes to the next person who is there second in line, or the project comes to standstill. So the policy needs to be defined so well that there is no halt in whatever inventions are going on, because substantial amount of energy, work and money goes into developing one thing. So organizations, when they develop these policies, now we have drafted this for 2 or 3 academic universities till now. So we keep it as broad as possible, so that everyone is benefited. It becomes a win-win for both the inventor, the person who's working, as well as the institute. If you keep it too stringent, then people will not work they will not go for any development. Yeah, so waiver of rights, so as I told him, that Mohit is required, then only the IP can be waived off. If the university decides, if you have a IP cell here, if your IP cell decides that I don't want to file a patent on this, and they feel that this idea has no value in terms of going for any IP, in that case also the management can decide to give it off to the inventor, and he can take it further for marketing. But that totally depends upon what your IP cell decides. Every organization compulsory needs to have an IP professional or an IP cell in place. Common people cannot decide on what is the value of any idea. And as I said, it's explicitly decided by the university to decide if it is for educational purpose. Now her copyright says she makes some 10 slides, something like this, and it is going to be useful for a bigger crowd to teach. In that case, they say, okay, we are not going to claim any IP on this, and we are giving free of cost to all the people who want to access. That is one where a waiver of rights come in. Now, your question on ownership of visitors. Okay, so you are going as a visiting professor somewhere, okay, and you are developing. In that tenure also you develop something, as well as in your parent organization you develop. In this case, the visitors have to assign it to the university. So wherever you have developed it, that parent organization, IP usually gets assigned to that organization only. because you cannot claim it on your own. It's always the university which has supported. So here this is your departure from the university. A visitor must sign and submit the IP disclosure that has been created to the IP cell which is internally formed. Now, who is responsible to disclose the IP? Okay, this is very important. Now, I think I have developed something. Who should I give it to? So, it is my responsibility that I approach the IP cell and I tell them that, see, I have an idea. I think this is patentable. So, what is your point of view? Okay. So, it is the responsibility of the person who is inventing or developing that idea that he goes and tells the IPO office that, see if there is any potential in this and whether we can file an IP on that. So this clause has been put into the IP policy just to streamline the processes of how IP should be disclosed. Only thinking that I can file an IP doesn't help. You have to have people in place, you have to have processes in place. Tomorrow when I have an idea, I should know whom I should go and talk to. So it's randomly I just going and speaking to anyone will not help. So every organization has a cell, they have lawyers, they have patent agents, they have now external agencies like us, like Venture Center, where you all have where you all have an MOU. So you can always approach us and say, see, this is what we have. We don't have an internal team, and can you help us to do it? So this is the responsibility of disclosing the IP. Institutional processes. Now, why this is important, I tell you. We usually have two committees in any organization. Okay. This is going more towards technical. Why I'm telling you all this, why our policy needs this. This is to make processes run in a smoother way. Okay. When one is the IPO office and one is the steering committee. Now, what happens in these two, I tell you. IP office usually looks into a day-to-day processing. What happens? I have an idea, I go and file it, then that person takes it further. Oh, uska what FER aa gaya, grant aa gaya, that routine processes which go on. Maintenance is there, whatever is the fees. That is taken care by the IPO. The higher authorities usually decide upon whether to file for a patent and when it goes for commercialization, does it have the potential to be commercialized. Okay. I feel that my idea is the best and I can get money out of it. But is it actually the scenario is what this committee is responsible to see. And this usually has your higher managements in it. So in your case, it could be head of the department. So you all have any tech transfer office related or your vice chancellors or whoever. So this is how the responsibility for an IP office is divided. This needs to be in place in any organization to effectively implement an IP policy. Okay? And they should be aware what is written in the IP policy. Now, as I said, when you all do an employment agreement, you all should know what is there in your list. So you all should know whom to approach if you have a problem. Now, this is a workflow and documentation. Now, this I have taken from NCL. I was working at National Chemical Laboratory. So there we have a separate cell for IPO, where in a year 150 applications are disclosed. So that you can see the volume at which research is done and the volume at which we receive inventions. Okay, so 150 invention disclosures we receive in a year, for which we have to do the filing. Okay, now how do we decide? Because what to be filed and what not to file. So every scientist, it's like their baby, so they're so proud of it and they're like, oh no, you have to file it. We have to face them, to even convince you people that, see, this is not patentable. If I tell you directly, you're going to be sad. Anyway, because if I say, see, this is useless, just throw it in the dustbin, it's not going to help. So what we do in an IP policy or in our documentation flow is, we try to segregate it in such a way that we make them understand, we give them an invention disclosure form. We first tell you, you disclose your invention. Then we understand whether this has to be patentable, it is not patentable. We try to extract information from you. See, because an inventor feels it is novel, and from the legal point of view, it being novel is different. Okay, so these processes are followed there. Then we file for a patent application, and then the entire process goes on. So whenever an IP policy is in place, there has to be documentation, there has to be an IP cell, which takes care of all these processes for a smooth running of any organization or IP. IP policy has to have this in place. It could be in a small factor, it could be in a larger factor. Now, organization like NCL, they don't file only in India, they file all over the world. So we have to take care of US also, we have to take care of EP also. So this documentation process always helps out.
If sort of criteria required for patent, but we are not interested in the commercialization.
Hmm.
So in that case, should we file the patent or?
See, patent filing and commercialization is two different things. Not necessary every patent, every product will be patentable, but it has a huge commercial value. Okay, so there are two different things. If you feel that your patent is only to avoid others getting into your field, you can file a patent. So that is how most of the bigger companies work. I'll tell you how they do it. I develop a drug. Okay, I show the efficacy, and I just file a patent. So it comes into public domain. She has the same drug. She cannot file a patent on that. Why? Because yours is already there in the public domain. So it is used as a negative right. Okay.
In that case, if I put the public.
She will also not get a patent, and you will also not get it. So that is the way it is negatively used also. Not necessarily you want to commercialize only out of it every time, but you don't want others also to patent it. Because if she patents it, you cannot use that drug. Okay? And you will have to pay her royalty because she is owning it for 20 years. 20 years is a big amount for any market. So instead of that, what you do, you only publish everything out. So it becomes free for everyone. So she will not only also, you will also. So that is how, other than commercialization, patents are used. One part is evergreening also, where most of the pharma companies keep on doing it. Just to prolong the life of your drug, you go on patenting, just modify it. But now it is reduced a lot. But other than commercialization, this is how patents are used. Commercialization always helps if you have a patent, it gives you an added value. So when we do a valuation of any company, so when there are mergers, or acquisitions, it is not only the property that is looked into. Your IP is also property. So when we do a merger acquisition study, we find the value of your IP also. How much valuation your IP holds, all forms of IP. So in that case, as she said, it was trademark. She wants to sell that trademark. So that has a value. What customer relation she has developed in the market. So that has some value for her trademark. So that will be value. The patents will be value. So this becomes important when you are selling of your product also, and how much. If you have an IP, it's always an advantage when you're commercializing.
And is there any weightage in case of like IP? A patent has the highest weightage.
No, IP valuation is totally a different ball. It is totally different. There are methods in which IP valuation is done.
In academic institutes, maybe submit the data to the NIL factory. They give more
NIL
weightage to the patents
yeah.
than the
But when we do valuation for mergers or any or IP due diligence, it is called as. When we do that, it is nothing like that. It is your total market valuation.
Ma'am, in case I invented something like a product and launched it in a public domain, like I'm not claiming it for myself, I'm launching it directly in the public domain, and after a while, after seeing the circumstances, it was observed that my invention is used as a for wrong purposes. So can I withdraw that and claim it again, or? So then,
Unless and until you have a legal right, you cannot sue anyone on it. You cannot show that it has been infringed. You cannot do anything on it because you don't have a legal authority.
in that case, what will be the correct procedure?
That will go into your civil law. It doesn't come into your patent law because you don't have an IP protection around it, right? You just developed a product and someone is using it illegally or in a different way in which it is not supposed to be, right? So in that case, it goes for a civil law. It doesn't come into the ambit of IP.
Okay.
For IP law, everything has to be protected under that IP. You either have to have a patent, you have to have a trademark, whatever. So if your trademark, someone is using in a distorted manner for something else, you can always go and sue that person saying that this person is using it in a wrong way because that has been registered on your name. So even for infringement or anything, you have to be protected by the law to infringe on someone, sue someone. Dispute resolution is, if there are two people who are fighting and they feel like the IPO office is not giving me due credits. In that case, there is dispute management. Usually, it is done internally by the committee members or people who resolve it. But this needs to be mentioned in the IP policy because many situations, if you all don't get along well with the colleagues, it happens in any organization. In that case, there should be some some clause in place to resolve the disputes. Policies need to be amended usually in the period of 3 years because situations keep on changing. There are new things which are coming up. Now AI is coming up. So what if a person comes with an AI? So how it will be protected? What will be the rules and regulations? So it is always advisable that you amend the policy. So just tell me how much time I have. What policy? Okay. So what I do is, this is a tech transfer policy. I will directly go to types of licensing, okay, and then revenue sharing, and then we'll understand in 5 minutes about entrepreneurship. Okay. Tech transfer is a different policy. Why? Because IP, you can say, is the parent. Tech transfer comes second in line. Third in line comes your startup or spin-off policy. Tech transfer policy helps you to understand what will be the division of revenue sharing in short. Okay, so X amount is received by the company, how much the inventor gets, how much the organization gets. Okay, there are different types of licensing agreements, which define the subject matter. Has anyone of you seen a licensing agreement? How technology is transferred. Forget all normal license. How technology is transferred from one person to another person. Anyone is aware of the process? Because then this will be total alien words for you. No one has seen? Okay. When we draft a licensing agreement, it has to give the scope of the technology that has been transferred. Okay. That technology might not be what you can see. So for a mobile phone, there is a technology that the camera is so much pixel, and you have got a feature where you can erase the background and I can just keep myself. So that is a technology. So when you write a licensing agreement, that technology needs to be well described in your know-how. There's a column which is called as scope of the license and the field of use. So these two parts you need to describe your technology. This happens under your tech transfer policy where you are defined what kind of transactions you are going to do. Okay, so it could be free of charge, you could claim royalty on it, you could say that lifelong royalty, upfront payment. So at only one time I will give her 10 lakhs and after that whatever I sell is mine. Okay, so this all happens in a tech transfer related policies. Responsibility of the inventors. This is another workflow which we have for tech transfer related policies, where there is a lead management and deal structure. Now, why we need to understand the agreement and deal structure here is, there are certain milestone payments which are done in licensing agreement. That is, at every stage, say every 6 months, she has to pay me 10 lakh rupees. Okay. The IPO office or the tech transfer office needs to keep a documentation that every 6 months I am receiving 10 lakh rupees from this person for the technology that I have transferred. So all this documentation, what is the know-how that has been given, whether this is an exclusive license, this is a non-exclusive license, all these document structures need to be kept in place by the TTO office. Okay? This is a level beyond your IP, so it gets more and more complicated as we go further. Okay. So just at one go, it's not possible to explain all the nitty-gritties of what you're saying. So this is the main part which comes in your technology transfer. Is the revenue share. Okay. Usually it is kept in this percentage. 60% goes to the university, 40% goes to the research. Okay. You have to prove yourself that you are the true inventor to get this 40%. If there are 3 inventors who are doing it, the 40% is divided into the 3 of you. It could be either equal share or it could be the share as decided by the first inventor. So it could be she will decide that you get 10 and you get 20. So this clause are usually defined in a tech transfer policy. Okay, and this is decided, every 2 to 3 years we also need to renew this terms, because sometimes agreements differ as you all sign it up for different projects. Okay, so this is how a commercialization process is defined. Just getting an IP doesn't help. You need to protect it. Once you protect it, you need to commercialize it. Okay. Now we have crossed this stage in our first lecture. We are trying to come to this stage. Okay. This can be done either by you selling it or you doing your own startup. Okay. that startup policy, how it is. So this is one very good picture I got from WIPO, where it tells how academic organizations can carry out their tech transfer. So what is the ecosystem you all need to have in place? What are the challenges? What is the processes that we need to follow? As I said, you need to have a policy, you need to have people in place, you need to have funds in place. And the outcome is you can get any form of commercialization. You can do a tech transfer, you can do sponsored research, you can do upfront payment, or it is just for research purpose that you are carrying. Faculty entrepreneurship is totally a different mindset, we can say, where you have to start your own business, okay, as a faculty also. It's not necessary that only a business, so Ambani can only do a business, it's not that. Even you as a faculty member can start your own business, okay. So how does this work in an academic organization? Now, we have created, it is called as a spin-out, okay. Spin-out is something, I am a parent organization and my child is spinning out to form a new entity. That is how this works, okay. So he is working at DY Patil. Tomorrow he decides that he wants to create a spin-out, a small company on his own idea. How as an organization I can support him? How as a parent organization I can support him? That comes under your entrepreneurship policy, okay. At NCL, when we were working out, many scientists have created spin-outs. These spin-outs are there at Venture Center. They have been passed on to their students. Now, as we were discussing, that she wants to start her own company, say on nutraceutical formulations. So how can she create it? With your help, okay? So that is all defined under an entrepreneurship policy. At many of our organizations, we are still not well developed with entrepreneurship policy. We are still caught up in IP and tech transfer. This is a bit more complicated. I have tried to explain. Entrepreneurship is, it is any business, but it has a lot of risks which are associated. You have to be full-time involved in it. You have to, like it is right from a PUM to a director, everything is only you. Okay, so there you have to put in a lot of energy. So that is, but what are the gains that you get out of it? If you are committed entrepreneur, are huge. Many Airbnb started with this small idea of just lending, giving your homes on rent. No one usually thought that this can happen. But today Airbnb has become a big company. Ola, Uber, very good examples of entrepreneurial ideas. So no one even thought that we can book a taxi on our app. But today they are becoming $1 million companies. Okay? So that is how an entrepreneurship idea starts. Now I tell you what is a spin-out. There are two entities in an organization. One is a startup, okay, which is totally done by you, where you are not connected to your organization. One is a spin-out, where there is equity holding by the organization in your company. So, say DY Patil, you have a spin-out. DY Patil owns 40% of equity in whatever product you develop as a spin-out. That is, why spin-outs are more comfortable to any person is, because you have the organization support you. Startups is usually, it is like entirely you on your own, and you have to market the product, you have to get funds, you have to have angel investors coming into your company and everything. Spin-outs usually help because you have the entire ecosystem who is supporting you. Okay, your faculty are involved, your student is also involved. Okay, now as a student, I decided that yes, I want to be major stakeholder in this company. With the help of the faculty, the student can set up his own spin-out. Okay. Now for all this to happen, there has to be some policy in place. So that is called as an entrepreneurship policy. Yeah. So how a technology transfer comes from a spin-out, I tell you. One is we identify the problem. Okay. We set certain proof of concept, and instead of selling it off to another company, I said, why not? I'll only develop my own company and I will start it out. Okay. So this is how spin-outs are created. You have a technology provider. He is a committed entrepreneur. He has that thing of becoming I want to form my own company rather than being an employee. Okay. So I become an entrepreneur. I get funding. Funding agencies are available. I'll show you a chart of how governments fund at different levels. And then I find a new spin-out company. This spin-out company is your parent company's part, where equity is held there by the organization, parent organization.
Say for example, whatever you said that the 40% is owned by the parent organization. In that case, later on, if I go for the venture capitalist or in the investor,
Still, you have to show that the 40% goes with the investor.
so would they still be interested in my product because a major
You have to convince them. You have to, yeah, you have to convince them. But then in that case, I tell you how it happens now. You know what we do at spin-out companies with NCL specifically. We have kept it as for 5 years. So for 5 years, Venture Center will have an equity of 10%. Or I buy your 10% shares at the rate of 10 rupees. So that's 4,000 rupees hardly. Okay. And in that, and after 5 years, I say that I'm going to reduce my share, my equity, in your company. So I keep on reducing it. So that is how you need to, make combinations by which you can convince the angel investor, saying that, see, initial 5 years I needed support, so I used to give them 40%. After 5 years, they have come down to only 2%. Or they are just buying minimum shares of 100 rupees, 10 shares in my company, just for the namesake. And say down the line 5 years, I take an exit for it. So that can be possible. But why this is important, because these are the developing years of any spin-out. And you only don't know whether your product is going to hold in the market. So in such cases, it is always good to have a back-end support. Down the line, in my 5 years down the line, you may think that no, this is not working and I'm just going to sell off and go into a job. It happens, all startups are not successful. I mean, we see it day in, day out at our place. So that is like, now I was telling her, like, that MyLab which came with that COVID kit. No one felt that, it will be so popular. MyLab was supported by venture centers. So, but today, they have not only developed it for COVID, now they have gone into many other ways of, because now they know the technology. So that is how they have developed on their angel investing. But if you keep only one product with the investor, it will not help. You also have to show the growth.
diversity.
Yes. It's like any other company, it's like any other company. Only thing is, this starts with baby steps, so you need that is why it's called as an incubator, where you are getting the support from the entire system. And spin-outs help in that case.
And also, I just wanted to ask that, is it like that it is recommendable to have a single-digit percentage equity sharing by the?
Not necessarily. But that depends how much confidence you can show in your product, right? So you say my product is hit. Now, as I was telling Ajinkya Daniya's pad care product, so he could develop that confidence, so he could get so much of investments. I mean, he was looking into a product, he's looking into a solution which is no one else, everyone knew there is a problem, but no one could find a solution. So now he's come into all schools and everything. So that confidence is always, dependent upon how you put up in mind. After all, this is all business. It's only that to support faculty members also, it's not necessary you only have to teach, you can also be an entrepreneur. So we have all these mechanisms in place. This thing stopped again.
No, it is working.
I just wanted to show one slide before that.
Before.
Yeah. So this I wanted to tell you what a faculty can be in terms of a spin-out form. So in what capacity he can be. He can be a mentor, he can be an investor, he can be a non-executive director, or he can be a consultant. This is in lieu with you working here. So with your responsibility as a faculty, you can also have these roles in the spin-out company. This all is defined how your relation with your organization goes and how confident you can develop on this. Okay. So this is a very important thing. Tomorrow I think Kavita will be also showing you. This is at different levels what funds are available by the government, okay, for any startup or any spin-out idea that you want to come. If I am at an idea stage, you get around 5 to 15 lakhs. This is available by the government without any return on investment is expected out of that. Okay? But you all should have good ideas. You all should be able to present your ideas. You all should be able to pitch your ideas to the investors and to the committee in order to avail this. So there are many ways in which you can develop your own company. You can come out as a spin-out, but that is all in your mindset, how you all think in an entrepreneurial way. Last stage you can see is when you get more than 10 crores is when you launch your product in the market. Okay. These steps are, it looks very simple. It is not this simple. There's a lot of work. There's a lot of support which goes on. There are many pitfalls. There are ups and downs when you go for a startup. But all this is available today when you go for any entrepreneurial kind of projects. Okay. That's it. So there is lot to do in entrepreneurship, but it's like time is short.
For research, we need some ethical approval.
Yeah.
So for patent, what we need. For example, just if I want to invent a pen, so I can create a picture diagram, like for
No, I didn't get what.
ma'am, like for research, for doing any research, we go through ethical committees. We need one research article, right? So for patent, I just have heard, I think I'm not aware. Now, if I want to patent a pen, okay? So